Hello, and in this video I'm going to be talking to you about a specific type of duress, economic duress. Now, previously we looked at normal duress, and what that basically means is as a party, you're forced to enter into a contract because there's been either a threat of violence or actual violence towards you. So, for example, in Barton and Armstrong, death threats were made, so the person had to enter into the contract to buy the shares. Economic duress is different because you're given sort of no choice other than to enter into the contract. It's not saying that, oh, I'm going to kill you, or I'm gonna or I've already sent someone to beat you up or something like that, but it's more to do with you have no other option to do other than to do this. Now, the first case where economic duress was discussed, but it wasn't successful, was in the Sibon and Siboteur. Now, what happened in this case was that the defendants had chartered ships from the claimants, and the defendants said that actually, if you don't lower the price, then we would go bankrupt. So the price was lowered. However, they later sought to have the contract made void on the grounds of economic duress. Now, the court said this is not economic duress because you actually had a choice whether you were going to lower the price or cancel the contract. And it wasn't that if you lost this contract with someone else, there would be no other contract to keep the business alive. You made that choice. And so they specified that for economic duress to exist, there has to be enough coercion to impair the consent. It cannot just be commercial pressure. So that's why it was a key case, even though it failed. Now, then we have a successful case of economic duress, which is in Atlas Express and Kafka. Here, the defendants agreed with the Woolworths that will supply you with baskets, and so they entered into a contract with the claimants, where the claimants were going to distribute the baskets to Woolworths, so they were like a carrier. Now, it was really impossible for the quantity of baskets that they had to find any other carrier, so it was as if it was a monopoly situation, and one party had a greater bargaining power. So they had to pay a huge amount. It was a very expensive contract. Now, they wanted to have this set aside because they said it was not fair and it was economic duress. We had no choice. And the court said, yes, this was economic duress and it's not going to bind you, the contract, anymore, because in new terms had been constructed out of no bargaining power, no negotiations, like, in the previous case, in the Sibon and Siboteur, there was, like, we're going to go bankrupt, and there was negotiations. Here, there was no negotiation. And also, they agreed to the price under compulsion. It was unwilling. They didn't want to, but they had to because they had already a contract with Woolworths. So in this case, what was applied was the judgment given in a case called Poweron and Li Yu Long. So I just call it the Poweron case because I don't know how to pronounce the whole name. Now, here I think basically it was the claimant threatened not to complete the main contract for some shares unless there was other agreements and other things that were met. So it was basically like no choice, but they had to agree on these other factors. Now, essentially, what was the crucial thing about this case was that the Privy Council identified 4 factors that had to be considered when taking a decision on duress. The first was, did the person who's claiming to have been forced protest? So in the bargaining power one in Sibon and Siboteur, yes, they did, sort of protest and say, but da 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 da. In the Woolworths case, no, they could not because that was their only option. Second thing is, did they have any other course of action? Well, actually, in Siboteur, yes, they did have other course of action. They could have cancelled the contract, said no, that's it. In Atlas Express, no, there was no other option. They had to do this. Third was, were they independently advised? Both times that was a no, but if they were, then that would say, well, how much of this is duress? You did get advice. And finally, after entering into the contract, did they take steps to avoid it? And clearly, the Woolworths case, they did because they brought it up to the courts, etc. Now, such external pressure and duress is not just to individuals, as we've seen, it's to businesses too. So in the Universal Essential, the Workers' Federation put financial pressure on a business that if they did not meet these financial pressures, then they would not allow the ship to leave the port, so they wouldn't do the work. Now, the court said that this was economic pressure because there was an absence of will. The business had no choice because they had to let the ship get out of the port. And secondly, the pressure was illegitimate. But it was hard for them to distinguish what was meant by legitimate and illegitimate. But in this situation, it was illegitimate because it was part of their job to actually make the ship leave the port. Now, it doesn't mean that if you can identify economic duress or, and this force and the illegitimacy of the pressure, that you're going to get a remedy. Because in the Atlantic Baron, the shipbuilders demanded extra, I think, 10% in price because of the dollar valuation, or they refused to build the ships. Now, as the purchaser had been in the midst of a deal of selling on the ship, they had no option but to say, okay, fine, we'll do that because we've already entered into a different contract. So this is similar to the universal assent here. However, the court said that we can't put this down and give you remedy because you're 8 months late in bringing the claim, and also you're bringing the claim after the second ship is sold. It's done now. You should have come to us before, and then we could have done it. So that's a bit of background onto economic duress. Thank you for watching.